Hello, I'm Lena Zworenstein, and I'm here because I do love our Constitution, and this is part of the American Constitution Society's initiative to foster discussion on the Constitution with a focus on the courts in law and policy. This is a national initiative and a teach-in that is being hosted the week of Valentine's Day, though it's always a great time to learn more about the Constitution and our courts. At the time of this recording, we have a new president who has put the federal courts in a new spotlight. He's often criticized judges and courts who disagree with him, even calling judges so-called judges. District and circuit court judges are being noticed even more as they've been on the front lines of determining the legality and constitutionality of the president's new actions. But even when it doesn't make the news, our courts are performing key functionings that impact all of our lives every day. What I'm about to explain is how our founders set up federal courts and the judicial nominations process. As you can see on the agenda, we're going to talk about the Constitution's Article 3 and discuss how our federal courts are set up. We'll also be talking about Article 2, which outlines the Senate's role in the judicial nominations process. Then we're going to be talking about vacancies that are happening on our federal courts, as well as that nominations process, giving a bit of an overview as to what's happening in terms of vacancies and nominations at all levels of our federal court. As you can see in the language of Article 3, Section 1 of our Constitution, it talks about how the judicial power is going to be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. In that, the Constitution really does only declare that there is one Supreme Court, but Congress gets to decide the district courts and circuit courts in terms of numbers and locations around the country. What's also important to note about what the Constitution states is that judges for both the Supreme Court and those lower courts hold their offices during good behavior. That has really been interpreted to mean that these are lifetime appointments, such that judges will not be dismissed from their role as judges unless they decide to take what's called senior status, or that they retire, or if they unfortunately pass away while serving. When most people talk about the federal courts, they think of the Supreme Court. Yet the Supreme Court only hears about 75 to 80 cases every year. More than 10,000 petitions are submitted to the court every year, but the court is able to select those cases which it will hear and make decisions on. Circuit courts of appeals also play a significant role. That is where more than 55,000 filings happen every year, and a lot of cases are also resolved. But the majority of cases are finalized in district courts. The district courts are all around the country, and they receive nearly 400,000 filings annually. Let's talk for a moment about the U.S. Supreme Court. The U.S. Supreme Court has 9 seats. There is one Chief Justice, and that is John Roberts. There are positions for 8 Associate Justices as well. By the point at which you're hearing this, there will have been one vacancy on that court for more than one full calendar year. The other 7 Associate Justices include Anthony Kennedy, Clarence Thomas, Ruth Bader Ginsburg, Stephen Breyer, Sam Alito, Sonia Sotomayor, and Elena Kagan. Now let's talk about the U.S. Circuit Courts of Appeal for a moment. There are 179 Court of Appeals judgeships that have been authorized around the country. These judgeships, as mentioned before, are something that Congress gets to determine from time to time. Congress can decide where the judgeships are located and how many there are. There are currently 11 circuit courts of appeals, as well as the D.C. Circuit and the Federal Circuit. These circuits are all defined based on geography. Congress can also change those geographic lines from time to time if it wishes as well. Similarly, the district courts are also geographically based. There are 673 district court judgeships that Congress has authorized. Those exist within states, and if a state has more than one jurisdiction, it is divided into other districts. So, for example, if you were to look in the state of Michigan, there is an Eastern District and a Western District. And within that, there are a number of judges that have been authorized to sit in those particular jurisdictions. Now, let's take a moment to go back to the U.S. Constitution to talk about how these judgeships are filled. According to Article 2, Section 2 of the U.S. Constitution, it states that the President shall nominate and by and with the advice and consent of the Senate shall appoint judges of the Supreme Court, as well as all other officers of the United States. Thus, both the President as well as the Senate have a significant role in how the nominations process happens. It is the President that gets to name and appoint the judges ultimately, but it must go through what is called the advice and consent of the Senate. In breaking down the judicial nominations process, we can look at a few different steps. The first step would be when a judicial vacancy is announced. And as mentioned, that's when a judge takes senior status. And what that means is that a judge has reduced his or her caseload and does not have the opportunity to have a full caseload, and therefore a judge would have to replace him or her. It's also possible that a judge has retired or announced retirement, or that they will be resigning. A vacancy may also be created when a judge unexpectedly dies while serving. What usually happens next then in the judicial nominations process is that a president would nominate, and that nomination would then go to the Senate Judiciary Committee, which has jurisdiction to evaluate the qualifications of those who have been nominated to serve at all of our federal courts. Then the Senate Judiciary Committee would do what calls reports out any of these nominees, saying that they are reporting them out favorably or sometimes unfavorably or without any recommendation. And then the final step would be a Senate confirmation vote. We'll break this down a little bit more as we go on. So let's take this first step when the president nominates someone to fill one of those vacancies. As part of the advice and consent role, home state senators, that is, the senators who live in and represent the states in which that judgeship has been created in and would fill, have a role in helping select those candidates that the president might consider to fill that vacancy. Typically what happens is that a senator will have a selection process through setting up a judicial selection commission, potentially having independent senatorial panels, or the senator, him or herself, will make the recommendations and calls on who they would want to recommend to the president. And then they would send those recommendations to the president for consideration. Those names, as well as any names that the president, him or herself, would want to review, then undergo extensive vetting and investigation from various people that are within the White House as well as the U.S. Department of Justice. Usually, depending on the administration, while the White House is reviewing the nominee, the ABA, or American Bar Association, may also be conducting a confidential review to declare the nominee as well qualified, qualified, or not qualified. In some administrations, this review would happen during the Senate review process as well. The final step is when the president would publicly make an announcement as to who he or she wants to fill that particular vacancy. So the next step of the process is the Senate Judiciary Committee evaluation. They evaluate nominees because it is within their jurisdiction to do so. Nominees typically complete and submit what's called a Senate Judiciary Committee questionnaire that has a number of questions that look very similar to a resume, that includes things such as past employment, important cases that he or she, the nominee, has tried before, and a little bit about the process, as well as going through some other background vetting. Then the Senate Judiciary Committee staff and members might conduct some further background research in order to reach any conclusions that they might, or to do any further investigation on that particular nominee. As mentioned, home state senators play a significant role in the advice and consent process. Another place where they play a role is in what's called the blue slip. This is a custom of the Senate Judiciary Committee whereby those home state senators, those senators that represent the state in which that nominee has been named to serve on a court within their state, has the support or opposition of that senator. Both senators then have this opportunity to submit this blue slip to indicate that they have either approved or opposed this particular nominee. It has been tradition that the chair of the Senate Judiciary Committee would not consider a nominee who does not have the support of both of their home state senators. This may not always be the case, but for now is certainly the tradition of the Senate Judiciary Committee. It's important to note that there are only home states for the district court as well as circuit court of appeals judges. While the circuit court of appeals judges sit on circuits that are regional and not state-based, each of those seats typically has a specific state in which that judge would be sitting, and therefore that would be the home state. And those home state senators would be the ones who would be submitting a blue slip. That's also true for the district courts, which are within specific states and would have home state senators. The only court that this does not apply to so far is the Supreme Court, because there is no home state and the Supreme Court represents all of the United States. Another part of the advice and consent process that the Senate is responsible for doing is hosting a Senate Judiciary Committee hearing for the nominee. This is a question and answer session with Senate Judiciary Committee members. There are sometimes public witnesses who can testify also at these hearings, or they can submit written testimony and letters of support or opposition as well. Also, there are what's called questions for the record. It's often the case that Senate Judiciary Committee members have questions that they don't have time to ask and have answered within the hearing. So therefore, they submit questions to the nominee that the nominee then responds back in writing to provide a more full answer. Once the hearing concludes, we move on to step 3, and this is where the Senate Judiciary Committee typically reports out nominees. The Senate Judiciary Committee holds what's called an executive business meeting to consider pending nominees or any legislation before it goes to the full Senate. And in that, they would consider any district court or circuit court or even Supreme Court justice who has been reviewed by the Senate Judiciary Committee to be reported. What frequently happens before a nomination is reported out of committee is called a holdover. This is where a senator who may have more questions for the nominee or needs a little bit more time to review that nomination would request that the Senate Judiciary Committee hold over for a week until the following executive business meeting that nomination for consideration to be reported out of committee. Once the committee is ready to report out a nominee, the nominees are usually reported out favorably, though the committee can still report out nomination in any of the following ways: favorably, unfavorably, without recommendation, or rejection. In any of these cases, the full Senate can still consider and vote on that particular nomination, although may do so without the committee's full endorsement. So then we get to the 4th step of the process, which is where the full Senate has the opportunity to review that nomination. That nomination, once it's reported out of committee, gets put on the Senate's executive calendar. Often at times, the nominee may be waiting a significant amount of time for that Senate floor vote to finally happen. But once it does, and if it is done so favorably, they are confirmed. What happens then is that the president would sign the commission, then that nominee would become a judge, and he or she takes his or her oath of office, and then they have a ceremony called an investiture, where they are then able to serve on that district or circuit or Supreme Court. Let's for a moment take a quick step back to discuss vacancies and nominations. As mentioned, a judicial vacancy arises typically when a judge retires, takes senior status, which means that they've reduced their caseload, they've been elevated, perhaps they've been nominated to serve on a circuit court or Supreme Court, or they've otherwise left office. Let's take a quick look to see what's happening at our lower courts. As mentioned, the bulk of judgeships are at the lower courts, the district and circuit courts of appeal. Approximately 13% of those judgeships are currently vacant. Many of them haven't been filled for a very long time. For example, the U.S. Circuit Court of Appeals for the 7th Circuit has been vacant for over 6 years. The Eastern District of North Carolina has been vacant for well over 10 years. In many cases, there are high caseloads as well. Where there's significantly high caseloads, it's called a judicial emergency, and currently there are nearly 45 such judicial emergencies around the country. Now, let's take a quick look at the Supreme Court vacancies. As mentioned, we've had a vacancy on the U.S. Supreme Court for over a year now. Based on Supreme Court nominations since 1975, we can take a look at what typically happens. A judicial vacancy, similar to the lower courts, is announced. The president typically makes a nomination. Usually that happens about 30 days from the time that seat goes vacant. And then the nominee would then have courtesy meetings with senators. And then the Senate Judiciary Committee, similar to what they do for lower court nominees, makes its evaluation. Typically, a hearing is held about 42 days from the nomination. Then the Senate Judiciary Committee would report out, either favorably, unfavorably, or without recommendation, that nomination, which is typically about 57 days from that nomination. Then the full Senate would have the opportunity for a confirmation vote, which happens about 70 days from nomination. As mentioned, we have had a Supreme Court vacancy for over a year, and that has certainly not been calculated into this particular timeline. If we take a little bit of a closer look at the current Supreme Court vacancy, we can piece out a little bit more the timeline. So on February 13th, 2016, Justice Scalia unexpectedly and unfortunately passed away. At that particular moment, Senate Majority Leader Mitch McConnell declared that he would not provide any consideration for any of President Obama's Supreme Court nominees, which was an unprecedented move. Yet, about a month later, on March 16, 2016, President Obama nominated Merrick Garland, who is the Chief Judge of the D.C. Circuit Court of Appeals. Until his nomination expired on January 3, 2017, Merrick Garland never received a hearing or a floor vote. In fact, he had been waiting 293 days for any consideration on his nomination. On January 31, 2017, President Trump nominated Judge Neil Gorsuch of the 10th Circuit for this same vacancy. We'll cover a little bit more about Judge Neil Gorsuch and other venues, but it's really important to remember just how important one justice matters on the Supreme Court. Justices serve for an entire lifetime or until they've retired or resigned, and therefore they may serve on the bench for decades to come. Indeed, there are numerous 5-4 Supreme Court decisions as well that have really shaped much of how we live our lives. Now, President Trump himself has applied a series of litmus tests to this particular nomination. For nearly the entire time that he has been campaigning since June, President Trump has also applied a series of litmus tests to this particular nomination. Since June of 2016, President Trump had campaigned as a candidate for president on the promise that anyone he nominates to the Supreme Court would do at least two things. The first would be to overturn Roe v. Wade, which is established precedent for numerous decades that allows women the right to make decisions about their own health care. In addition, President Trump has also stated that he believes that whoever he nominates to the Supreme Court would also defend his vision, or the NRA's vision, of the Second Amendment. There's a lot that we can glean from his record in terms of how Judge Gorsuch may comply and actually meet and pass these litmus tests that President Trump has promised. But I think that there's a lot of questions to be asked about whether or not he's within the mainstream or outside of the mainstream. And there are numerous questions that senators must ask. Because senators have a vital role in advice and consent, the Senate Judiciary Committee, in its hearings, must ask very tough questions that get to the root of some of the concerns that many have regarding not only the litmus test that the president has enunciated, but also that the president himself has been very critical of courts as an entire institution and what this particular nominee can do to ensure independence. Of course, they must also ask very difficult questions about his own record and how he would distinguish from his service on the 10th Circuit in Colorado to what he might do on the U.S. Supreme Court if he's confirmed. As a quick reminder, the U.S. Supreme Court's job is really to decide disputes between states and, most importantly, really decide important questions of federal law. Federal law usually comes from two places: laws that the Congress has passed and from the U.S. Constitution. So therefore, it has an important role in determining the legality and constitutionality of actions taken by many people, including our own government. So some of the rights under the U.S. Constitution include free speech, assembly, religion, petition, gun ownership, freedom from unlawful searches and seizures, the right to a lawyer, and so on. Cases such as employment discrimination, environmental regulations, healthcare access, marriage equality, reproductive rights, voting rights, immigration, and so on are determined by our federal courts. Certainly, these are really important things to remember as we're evaluating district court judges, circuit court judges, and also the Supreme Court judges. There are a lot of questions that are on everyone's mind, especially as they're considering the Supreme Court vacancy. There are numerous Supreme Court cases, especially in recent history, that have determined things such as marriage equality, access to contraception, voting rights, and so on that have impacted our daily lives. Senators, especially those on the Senate Judiciary Committee that have the opportunity to question Judge Gorsuch, will have the opportunity to probe into numerous areas of his record and his beliefs in order to try to determine how he might be as a Supreme Court justice. It's important, if you have issues that you care about, to raise those with your senators to make sure that they are asking the right questions and able to get information, so that if you're interested in learning more about judicial nomination, there are numerous websites that might be able to help. For example, uscourts.gov provides history, where judgeships are authorized, a list of judges, where there are vacancies, and so on. The Senate Judiciary Committee's website, which is www.judiciary.senate.gov, also hosts a variety of information, including their hearings, where you can watch live as to what's happening or see old hearings as well, and you can review those questionnaires and questions for the record that nominees are required to fill out. And you can also get more information at judicialnominations.org. People often ask me what they can do to engage in the judicial nominations process. The first thing is to learn about the specific vacancies that are in your state. Are there any where you're located, either in your city or in your state, or perhaps within that circuit in which your state sits in? You can find out more about that at judicialnominations.org or uscourts.gov. You can also talk to your senators. Ask them about vacancies that are in your state, whether they're current or future, or if you don't know of any vacancies there, that's okay. Just talk to them about the importance of the courts and judges, and ask them if they know about any vacancies that might be happening in the state now or in the future. Also, talk to your senators. Tell them what's important to you. You might care about climate change, you might care about immigration, or you might care about reproductive rights or voting rights or anything else. Let them know what's really at the top of your mind, because the courts most likely will have a significant impact on those specific issues. And you can engage in the process, whether it be in the selection process or the confirmation process. By having active conversations with your senators and your peers, you can participate in what's happening and understand the various steps along the way, whether it be watching televised confirmation hearings or understanding that a Senate floor vote is taking place. You can be a voice in that process. Another thing that you can do is to tell others about the courts, their importance, as well as the judicial nominations process. By breaking it down and making it accessible, even more people can feel empowered to understand what's going on in a process that can sometimes not seem as transparent or as easily understandable. I hope that this has been relatively helpful. Of course, should you want more information, please feel free to access any of those websites that I've mentioned. In addition, please feel free to check out acslaw.org for more information about why courts are important and more information about the judicial nominations process. Thank you.